Good morning. Happy Wednesday. Happy hump day. So, thank you, Big Jim Finch, for posting the appeal notes for Lane Myers. Apparently, he has asked for an extension of time in the civil. I want to make sure everybody understands this, in the civil injunction against harassment case. This has nothing to do with criminal. He's not filed an appeal on the criminal case that I'm aware of. I believe he's waived those rights, so we'll see if that ever comes about. But on the civil injunction against harassment, he has asked for an additional motion to extend the time. He filed a motion to extend time to file his appeal. He now has until July 17th to file the actual brief, the appellate brief. Now, there's a couple things that I want to point out. Just as a matter of course, it's meaningless at this point. There's now a criminal protective order in place. He agreed to. I don't know what they call it in Arizona, but there's a criminal protective order that is preventing him from contacting the victim. So even if the civil injunction against harassment is somehow magically vacated entirely, and the Court of Appeals finds that it was wrongfully granted, and they find that and they rule that it should be vacated and not remanded back to the trial court for further decisions or briefing or whatever, which is not going to happen. I mean, the odds against it happening are infinitesimally low. But even if that does happen, it doesn't change anything. Now, while I did say, and I do believe, that there were grounds for appeal on the civil injunction against harassment, the judge using unpublished briefs, unpublished cases, uncitable, non-citable cases to support his decision, and using cases that dealt with the criminal harassment statute and the criminal harassment definition, not the civil harassment statute and the civil harassment definition. Because he did that, I do believe there are appealable issues. I've never believed, and I still don't believe, that it will result in anything dramatically different. Best case scenario, in my opinion, on the appeal is it gets remanded back down to the judge to make a new determination of whether or not the injunction against harassment should issue, and considering that there is a criminal injunction against harassment, or criminal protective order, whatever they want to call it, in play, and he pled guilty to stalking and harassing, in a felony stalking and felony harassing in the criminal trial. There's just no chance in hell that if it does get remanded back down to the trial court, that the trial court won't find that there's grounds for the injunction against harassment. It's just not happening. He can take judicial notice. My guess is he can take judicial notice of the findings in the criminal court case. And it was a pleading of guilty, not a pleading of nolo, which means that the guilty plea can be used in civil cases, and the civil harassment is a civil case, and blah, blah, blah. So it's meaningless. Smoke and mirrors, it's meaningless. But one interesting thing so I was retained by an attorney who I work for, so I guess he wasn't really retaining me. He just had me do, as my normal of counsel work on his personal case. It was a domestic violence case, and he got a domestic violence restraining order. I did the work on that. Then opposing party appealed it entirely frivolously, and I did the work on that. And then when it came time for to request an extension of the domestic violence restraining order, I did the work on that. And one of the rationales, one of the reasons that I presented to the court for extending the DV, we asked for a permanent extension. It was granted, but we cited this frivolous appeal, this baseless, frivolous appeal, and how the Court of Appeals, decided it was baseless and frivolous, and but we use that as an example of further harassment. The opposing party dragged this appeal out for years. It was actually like 2 years the appeal process was 2 years because of her delays and everything like that. So yeah, it was 2 years. Yeah, because like, yeah, he got a 3-year restraining order. She filed her appeal at the last minute. It took the court a while to get the court reporter's transcript and the court clerk's transcript together. She had to amend her appeal. Yeah, it was closer to 3 years from, because like right when we were done with the appeal, I was preparing the paperwork to extend the DV permanently. So yeah, I mean, it was closer to 3 years. But we use that as evidence, and so my thought process is, if he pursues this appeal, that it's frivolous at this point, it's meaningless, it doesn't matter. I'm wondering if the DA might construe that to be him causing contact with the protected party, the victim, without good cause, without some sort of an excuse, some sort of a reasonable excuse. I'm just wondering. I'm not saying that this will get him in trouble. I'm saying I wonder if this could get him in trouble, because basically he's forcing further contact with her when it's not going to change anything. Anyway, that's my thought for the day. It'd be interesting. It'd be interesting to find out. It will be interesting to find out, because he's like a dog with a bone. I don't think he's going to let this go. I think he thinks in his head, and this is me mind reading, so, do with this what you will. Just my opinion, bro. It's not a legal opinion. It's just an opinion, for those of you who aren't following along. But he's like a dog with a bone. Like, he filed the motion for a further extension of time 2 days ago. So he's still thinking, like, he's chasing this. Like, why he would, I don't know. But it does not bode well for once he is, in theory, released on probation or what have you. It doesn't bode well for him. So, anyway, I guess we'll see. The saga continues. Thanks for watching. Have a great day.